Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. We have another docket update today in the Justin Baldoni legal case. Now, this is actually not pertaining to the complaint against Blake Lively. This is strictly to do with the New York Times. Yesterday, I read Justin Baldoni's objection to their motion to stay discovery, which is basically the New York Times was saying, like, we would like to, pause on the evidence gathering phase of this. And I read their motion for stay as well. So if you missed that stream, there's a quick one. You can watch it in my YouTube channel under the live stream tab. I'm going to wait just a minute here to see if anybody else wants to filter in before we read this document. This is not going to be a very long one, guys. No worries. But the judge, it's like 3 or 4 pages of writing. So it's not all as bad as it sounds. From what I've seen, I did just skim over it. And I'm going to have my friend Omar, the Tilted Lawyer, join me tonight for a live stream to talk about some of the recent motions and what this all means, as well as ask him questions about Taylor Swift, the deposition. Could she get out of the deposition? How that might go. So we'll talk about that tonight, probably around 7 or 7:30 p.m. I haven't decided yet, but once I do, I'll put that on my YouTube page under the post tab, and I'll also put it on my X account. So we'll get started on reading this in just a second. I want to see if anybody else wants to come in and join us. But like I said, it's not really as bad as it sounds. The judge did grant the New York Times motion despite the, objection, but it's not the worst. And Omar will be able to explain that even better than I can, because I'm not a lawyer. As you guys know, I'm just a random person like you, giving a random opinion. That's why it's the Court of Random Opinion. So, all right, let's get into it. And then I have to get back to work for a little bit because, as you guys know, I do most of this stuff on my break during my work day, which is why I do a lot of these updates as a live stream instead of an edited video. It's because I don't have time to edit a video. All right, here we are. And thank you, everyone, for joining me. Thanks to all my new subscribers. I really appreciate you being here. I've got to say, I still can't believe I'm seeing all this growth on YouTube. And I'm hoping that one day, this can become more of a full-time thing where I'm not just doing it in the middle of my workday. So we'll see. All right. So this is from Judge Lyman, and I may be saying the judge's last name, or I'm not sure. Consolidated defendant, the New York Times, moves pursuant to Federal Rule of Civil Procedure for stay of discovery. The motion is granted. A motion to dismiss does not automatically stay discovery, except in cases covered by the Private Securities Litigation Reform Act. Okay, and you guys know, I'm going to ask Omar about all this stuff, so we're not going to go through all the cases, like the specific case citations here. I will try to read through some of these quotes, though. Upon a showing of good cause, however, the court may grant a motion to stay discovery pending decision on a motion to dismiss. Together, these provisions enable the district court to stay discovery where a resolution of a preliminary motion may dispose of the entire action. Okay. A stay must be justified based on 1, the breadth of discovery sought and the burden of responding to it, 2, the prejudice, if any, to the opposing party of an order granting to stay, and 3, the strength of the motion. On January 31st, Consolidated Plaintiffs Wayfarer Studios, Justin Baldoni, and etc., we know those guys, named the New York Times as a defendant in their first amended complaint. The first amended complaint was served on the New York Times on February 7th. On February 28th, the New York Times filed a motion to dismiss the first amended complaint against it under Federal Rule of Civil Procedure 12b-6 for failure to state a claim for relief. The New York Times motion presents substantial grounds for dismissal, and the New York Times has made a strong showing that its motion to dismiss is likely to succeed on the merits. He's not ruling on that, guys. He's not ruling on that right now. This is just part of the explaining why there's a stay of discovery. Indeed, the Wayfarer parties note that their complaint may need to be amended to address the issues raised by the motion to dismiss. So they may have to do a second amended complaint, is my understanding there. See docket number 117 at 3. So let's take a look at that really quick. Let me show you guys where I find all this stuff. Okay, I'll move my head out of the way. Lauren, move your head. There we go. 117. So this was 118. So 117 right here. This is the opposition that we read yesterday. C117 at 3. So what we're going to do is I'm going to pay 40 cents for this again because I'm too lazy to go find it in my folder. You guys can see this, right? Yeah, there we go. Ooh, at 3. Where's 3? I don't want to spend too much time coming through this since we just saw it yesterday, but it did say 117 at 3, yes. See docket number 117 at 3. Interesting. Okay. Yeah, I don't know exactly. Oh, here. Third, the Times has not made a strong showing that the Wayfarer party's claims are unmeritorious. As part of the merits analysis, courts have also considered whether a pending motion to dismiss will dispose of the whole action. Here, other than the Times, there are a dozen parties who will remain parties, and the Wayfarer parties do not presently intend to move to dismiss Miss Lively's claims. Therefore, the Times motion to dismiss will not dispose of the whole action. Huh. That doesn't really make sense. Hang on. Okay. Here it is. I just had to search the word amend. For good measure, the Wayfarer parties intend to seek leave to amend their pleadings to remedy any defects therein that might otherwise support the Times motion to dismiss. So I actually kind of skimmed over that yesterday. I guess they do intend to amend their complaint again, I guess. Anyways, let's go back to today's docket update here. The Wayfarer parties argue that discovery against the New York Times will not be voluminous and burdensome because it will cover a relatively narrow time frame. But the burden of discovery is not measured only by the number of pages the movement will be required to produce, but also by the complexity of the issues that discovery will present and the sensitivity of the documents that will be requested. Okay. The New York Times has indicated that to the extent discovery is sought against it, the New York Times intends to invoke its right under New York Shield law. And then there's another reference to a different docket, but we're not gonna go through all that other document, guys. The reporter's privilege is intended to protect the public's interest in being informed by a vigorous, aggressive, and independent press by limiting the circumstances in which litigants may obtain access to press files through court-ordered discovery. The application of that law raises delicate and complicated issues, which would increase the burden of responding to discovery. Moreover, the dimensions of the discovery that is permitted may vary depending on whether the New York Times is a defendant or a third party, and whether it was acting in a journalistic capacity or, as the Wayfarer parties allege, as a co-conspirator with the Lively parties. Okay. And then here he's citing Baker v. Goldman. It says qualified privilege may be overcome by a showing, among other things, that the information is critical or necessary to the maintenance of a party's claim, defense, or proof of an issue material thereto. Berlinger said those who do not retain independence as to what they will publish but are subservient to the objectives of others who have a stake in what will be published have either a weaker privilege or none at all. The judge writes, those issues will invariably be affected by the court's decision on the motion to dismiss. Finally, the Wayfarer parties are unlikely to be unfairly prejudiced by a stay while the court decides the pending motion. The New York Times did not delay filing its motion. It filed the motion within 21 days of being served. The court intends to address the motion to dismiss promptly after it is fully submitted. To the extent that the Wayfarer parties are concerned about delay, they have it within their power to accelerate their contemplated further amended complaint or their opposition to the motion to dismiss. It's interesting because they haven't written their opposition to the motion to dismiss yet. Right, so yesterday was their opposition to the stay of discovery, which is what the judge just granted. But they have not yet put forward an opposition to the motion to dismiss. The Wayfarer parties themselves suggest that discovery from the New York Times is unlikely to be voluminous. To the extent discovery is sought from the New York Times as a defendant, it can be requested if and when the court denies the pending motion to dismiss. In the meantime, it is evident that the parties will be busy with document discovery from the other parties and with third-party discovery. Depositions are not anticipated to begin soon, and the court hopes to decide the motion well before they do begin. And as you guys know, earlier today, I did a video because Taylor Swift has apparently been formally contacted about depositions. Apparently, Justin Baldoni's attorneys or a representative for Justin have contacted her as she's meant to be in the first round of depositions. But as the judge says here, they're not anticipated to begin soon. So we'll see how that goes. And like I said, we'll have lots of questions for Omar, the Tilted Lawyer, tonight on some of this legal stuff. I'm going to keep an eye on this docket for the rest of this afternoon up until that stream tonight, because Justin's attorneys usually respond pretty quickly. So I don't think it's going to be very long before we see a response to that or some kind of action. So just stay tuned and hit that notification bell, and you guys will get notifications for my next stream. YouTube is notoriously bad at sending notifications even when you signed up for them, but it's worth a shot. Let's see. What actually does this mean? So the motion for stay of discovery, it means that the New York Times does not have to start the evidence gathering phase of this yet. So like if Justin and his attorneys and the Wayfarer parties were to want information from the New York Times, they would not yet start gathering that until after the motion to dismiss has been ruled on. That is what the judge just approved. Hopefully I explained that okay. Like you guys know, I'm not a lawyer, but that's certainly what it sounds like to me. And no, the motion to dismiss has not been ruled on yet because from what we just read, Justin and team apparently intend to file a second amended complaint, which means, you know, they're going to add more stuff to it that would kind of bolster their case a little bit. So my lawyer friend Omar, like I said, is going to come on my channel tonight, and we're going to discuss some of that stuff. And if you guys have any questions for him, he's a great resource and also just like a really funny, nice guy. And he's a very smooth, calming voice. I myself am immune to it, but all the ladies in the chat seem to think so. So, all right, guys. Correct. I just want to emphasize one more time. Correct. The entire complaint has not been dismissed. No. Just the stay for discovery was approved. And that means we're going to have to, you know, see a little bit more arguing back and forth, which is, I'm not going to lie, a little entertaining for me. So, all right, guys. Like I said, that was a quick live, but I'll be back later tonight. Just keep an eye out. And if anything else comes on the docket between now and when I do my live stream tonight, I will just have to do an extra stream because, you know, I'd like to get to it right away. Okay, see you, everybody. Thanks for watching. Thanks for the support. Please don't forget to hit the like, and I will see you soon. Bye.